So Chuck says, Midland Credit Management sued me claiming I owe the debt, but the only thing they attached to the complaints last 2 months of credit card statements. Should I include lack of standing as defense or wait until the pretrial conference to bring up these issues? Okay, so very good question, Chuck, on that. And so some of this is going to depend on where you are. Okay, so I defend lots of people sued by Midland, and I do that in the state of Alabama. And in Alabama, they do not have to really provide anything. I mean, they can just file the suit and say, and they literally used to do this, and just would say, Midland Funding is suing John Watts for a debt he owes. Like, no details. Is it a credit card debt, a car loan? What's the account? Like, they wouldn't put anything. It was terrible. Now they usually identify it's this credit card account, and they'll put a couple of statements on there. Well, in terms of what you do, again, that's going to depend on your state. I'll tell you what we do in Alabama is we would deny owing that debt to Midland. We would deny that Midland owns the debt, and we would put Midland's not the proper party to bring the suit, and just sort of say it in plain English. Midland does not own the debt, and then we would see what do they do. So if it's small claims or district court in Alabama, which that's typically under 20,000, then you file your answer, and 4 or 5 weeks later you're standing in trial. Okay. Now with circuit court, which there's some overlap in our courts. So circuit court's where we have our juries, and then below is district and small claims, but these amounts overlap. So sometimes they have a choice. So they file in circuit court or district court. Circuit court, it might be a year before you're at trial. They may file what's called summary judgment. And so you have to sort of understand the lay of the land in your particular state. Like I said, in Alabama, we would just answer that and then see what they do. Because ultimately, whether they're trying to get summary judgment, which is just telling the judge, no need to have a trial, just summarily enter judgment, or they're going to trial, they still have to prove their case. They still have to prove they own it. And so we can point out that defect. I usually don't push them hard to produce that because it's obvious that they have to produce the purchase agreement to show that they really own this debt. I mean, it's like, me and my personal injury cases, the defendant doesn't say, well, if John doesn't prove that his guy was actually in the wreck, what am I going to do? No, you win if I don't prove my guy was in the wreck. Okay. So, there's just certain things that the plaintiff, the one bringing the suit, has to prove. And I think showing that they own the debt is certainly one of those. And two statements, what does that prove? It proves they've got two statements. I think the statement should be from zero, whenever you were last at zero, to the last balance. And they should have a statement showing that. Because when they just produce the last two statements, the second statement probably says you owe like $4,673. Well, how do we know you owe that? We really need to see those previous statements. So that's the approach that I would take, and definitely get with a lawyer in your state. Even if you're, thinking you're going to do it on your own, just check with a lawyer to see kind of what do the judges want in your state and how does that work.